एक्सरसाइज करी कब, अंडरटेक कब करी, ये तो बता दीजिए।
Lordship, my respectful summary, it may not be admitted, notice may only be issued.
It is not your discretion.
चलिए Lordship, admit में तो 20 साल के बाद जाएगा Lordship।
ठीक है, क्या कर सकते हैं?
गरीब आदमी के साथ ऐसे ही Lordship अन्याय हो गया, इसके जुडिशियल डेथ कर दिया Lordship ने।
I can issue a contempt notice against you for all these utterances.
Lordship,
I can issue a contempt notice.
Lordship,
you have no business to make any of these comments. If you are dissatisfied with the order, you can approach the High Court. You have no business to make these comments.
For the High Court.
No, I have passed the order. I have heard you. I have passed the order. You have no business to comment on the order.
Lordship, this is
you should know your limitations.
Award has been passed in favor of the petitioner, Lordship, and he has submitted so many representations before the authorities, but they are not reinstated, and neither.
इस अवार्ड को, ये अवार्ड जो है ये इंडस्ट्रियल कोर्ट का है ना,
इंडस्ट्रियल,
हाँ, तो उसको एग्जीक्यूट करिए। आईडी एक्ट में प्रावधान है उसको एग्जीक्यूट कराने का।
सेक्शन 29 आई थिंक लॉर्डशिप,
आई थिंक तो आई डोंट नो, आपने पढ़ के आए होंगे
लेबर कमिश्नर के पास है क्या, एकदम
अब जाके उसको एग्जीक्यूट कराइए। हम क्या करेंगे यहाँ पर?
क्रिमिनल कंप्लेंट आता है सर उसमें।
लॉर्डशिप कंप्लेंट है या लॉर्डशिप में काइंडली सी द डिवीजन बेंच ऑफ द जजमेंट
इज द एग्जीक्यूटिंग अथॉरिटी। ऐसा कहा गया डिवीजन बेंच से?
नो लॉर्डशिप, if the lordship I permit, then I will
please
read the relevant.
Please read. इतना पढ़ के बता दीजिए कि इंडस्ट्रियल कोर्ट के आदेशों की एग्जीक्यूटिंग एजेंसी हाई कोर्ट है।
Lordship, may kindly see in this petition, which is filed under Article 226 and 227 of the Constitution, the petitioner has prayed for the issuance of a writ of mandamus to respondent number 1 to comply with the award dated June 15, 1992, rendered by the Central Industrial Tribunal in reference ITC number so and so, by which respondent number 1 is directed to reinstate the petitioner in service with 60% back wages and pay 1,000 to union by way of a cost of difference. This is the Lordship, the fact. And Lordship, may kindly, I would like to read the paragraph number 7. It was pleaded on the behalf of the respondent number 1 that the alternative remedy is available to the petitioner under section 29 and 33C(2) of ID Act, and therefore the petitioner should not be entertained. In our view, respondent number 1, having shown scant respect to the award of the tribunal and having failed to fulfill his obligation under the award, is not entitled to raise the plea of alternative available of alternative.
Respondent तो अभी है ही नहीं, नोटिस ही नहीं है। हम आपसे पूछ रहे हैं, have you approached the industrial court under section 29?
आगे ये भी डिस्कस किया हुआ है लॉर्डशिप, आगे ये भी डिस्कस किया।
क्या किया जी?
यहाँ पढ़ रहे हैं लॉर्डशिप, पढ़िए। And it is not entitled to contend that petitioner should be non-suited for his alleged failure to avail the alternative remedy. It is well settled that the rule of the not entertaining the writ petition under Article 226 or 227 is a case where equally efficacious alternative remedy is available. It is a rule of the self-imposed restraint and rule of cautions. It is not a rule of law, nor it is a rule of thumb, which can be applied in every case non-suitor petitioner, irrespective of the nature of his grievance. Whenever an objection is raised by the respondent to the maintainability, entertainability of the petition on the ground of the availability of alternative remedy, the court has to find out as to what is the nature of the grievance made by the petitioner and what type of the remedy is available to him. The court cannot be too oblivious to his constitutional duty towards the citizens, because time has come when the people have started feeling that they have been let down by the two organs of the state, and they look upon the courts with a ray of hope. Moreover, the apex court has given wider meaning to the term life, and right to livelihood has been recognized as a part of the right to life guaranteed by the Article 21 of the Constitution. The court cannot shut its eyes from the reality that in our country, public employment is an important source of livelihood to the individuals. If the court have safeguarded the right to speech and expression, the right to business, the right to property, the right to force of association, it cannot be oblivious and ignorant of the right of millions who are deprived of the source of livelihood by arbitrary, capricious, and whimsical action. The court cannot throw out the petition merely because it has been filed by the small man by declaring that he has an alternative remedy. Even otherwise, remedy under section 29 and 33C(2), the Industrial Dispute Act, cannot be considered as equally efficacious alternative remedy, which could be made a ground to deny relief to the petitioner under Article 26 of the
order दिखाइए।
आगे उन्होंने 29 के बारे में डिस्कस भी किया है कि इसमें मिलता क्या है। कि 29 एक्चुअली रेमेडी है नहीं।
पढ़िए 29 सेक्शन 29 तो पढ़िए पहले।
मैं पढ़ रहा हूँ।
हाँ 29 पढ़िए फिर देखते हैं।
29 is not an alternative remedy.
पढ़िए तो।
Section 29, Lordship. Penalty for breach of settlement or award. Lordship. Any person who commits a breach of any terms of any settlement or award which is binding on him under this act shall be punishable with imprisonment for a term which may be extended to 6 months or with fine or with both. And bracket my lord, and where the breach is continuing, one with the further fine which may be extended to 200 rupees or for every day during which the breach continues after the conviction of the first, and the court trying the offense, if it finds the offender may direct that the whole or any part of the fine realized from him shall be paid by way of compensation to any person. 33 lordship. Section 33, conditions of service, etc. to remain
33C2 वकील साहब आपको प्रोविजन ही नहीं मालूम है।
33C2 lords.
अभी आप जजमेंट पढ़ रहे थे गुजरात हाई कोर्ट
33C.
33C2 जी पढ़िए। आपने ये एक्सरसाइज करी कब, अंडरटेक कब करी, ये तो बता दीजिए।
जी लॉर्डशिप।
33C2 की एप्लीकेशन, 29 की एप्लीकेशन लगाई कब आपने इंडस्ट्रियल कोर्ट के सामने?
लॉर्डशिप ये सिर्फ ये कह रहा है जजमेंट कि ये हमारी रेमेडी रीस्टेटमेंट की है ही नहीं, हमारा ग्रीवेंस है हमारा रीस्टेटमेंट, और रीस्टेटमेंट के बाद हमारी रिकवरी लॉर्डशिप। तो 39, 33C2 और 29 हमारा कहीं रीस्टेटमेंट तो हमें दे नहीं रहा, उसमें वो कह रहा है 2 फोल्ड्स में है, एक तो उनको पीनल प्रोविजन है, दूसरा उनके लिए पेनाल्टी प्रोविजन है। तो उनको
सब्जेक्ट टू द objection raised by learned government advocate in regard to availability of the alternative remedy under section 29 and 33C2, petition is admitted for final hearing. Issue notice to the respondents on payment of PF by registered AD post within 7 days, returnable 6 weeks.
Lord, to my respectful summons, it may not be admitted, notice may only be issued.
It is not your discretion.
चलिए लॉर्ड से एडमिट में तो 20 साल के बाद जाएगा लॉर्ड।
ठीक है, क्या कर सकते हैं?
गरीब आदमी के साथ ऐसे लॉर्ड से अन्याय हो गया। इसके जुडिशियल डेथ कर दिया लॉर्डशिप ने।
I can issue a contempt notice against you for all these utterances.
Lordship,
I can issue a contempt notice.
Lordship,
you have no business to make any of these comments. If you are dissatisfied with the order, you can approach the High Court. You have no business to make these comments.
For the High Court.
No. I have passed the order. I have heard you. I have passed the order. You have no business to comment on the order.
Lordship, this is
you should know your limitations.
This is admitted lordship cases.
So
it will go to 20 after 20 years lordship.
Next case.
Serial number 24.
आप लोगों ने वकालत करना सीखा नहीं है अभी।